On August 20th, 2024, defendant Darren Wilson was charged in the 14A District Court in Washtenaw County, Michigan with kidnapping, armed robbery causing serious injury, first-degree home invasion, unlawful imprisonment, assault with a dangerous weapon, possession of a firearm by a felon, and carrying or possessing firearm when committing or attempting to commit felony. A preliminary examination, which is a hearing held in felony cases to determine whether there is probable cause to support the charges, was scheduled on November 26, 2024, in front of Judge Cedric Simpson.
Most Honorable Court, Edward Martell, P85051. On behalf of Darren Dwayne Wilson, sir, please stand and give your full and complete name for the record.
Darren Dwayne Wilson.
Thank you.
Your Honor, today is the date and time scheduled for a preliminary exam. I believe that Mr. Martell would like to start us off by motioning for Your Honor to accuse himself of this case.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, did the sole basis that the people intend to introduce quote unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that counsel is attempting to.
Well, then I'll let him finish, because I don't know. It did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case. And specifically, the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue, because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position,
does that case clearly apply to search warrants?
No.
Judge, it's not limited to search warrants.
But that isn't what I asked you, Mr. Martell.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge,
just by the very words that you said, and certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that is clear. I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martell, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Mr. Wilson's criminal defense attorney, Edward Martell, argues that Judge Simpson should recuse himself from the case because he had previously signed off on a search warrant that produced information incriminating Mr. Wilson. Citing the 1974 case of People v. Burrell, recusal is the formal process by which a judge steps aside from presiding over a matter, typically because the judge has a conflict of interest or an appearance of partiality that could call the fairness of the proceedings into question. In the Burrell case, the Supreme Court of Michigan recognized that a judge who was already heard ex parte testimony from witnesses in connection with the issuance of a warrant may not be wholly objective when later asked to preside over the preliminary examination. The court stopped short of categorically barring judges from presiding over a preliminary examination under those circumstances, but it made clear that a defendant's request for a different judge in such cases should be regarded as reasonable. Accordingly, Mr. Martell's position was that Judge Simpson's prior involvement in authorizing the search warrant placed him in precisely that posture, and that fairness to Mr. Wilson required a different judge at the preliminary examination.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, to the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right.
Court recalls case of the People versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martell, P85051, on behalf of Darren Dwayne Wilson. Please state your name once again for the record.
Have a seat. So, Mr. Martell, I'm a bit concerned. I just take what people give me, but I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. Then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not, but
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge Simpson returns from the recess with sharp words from Mr. Martell, arguing that he lied to the court, both through his suggestion that Judge Simpson was the one who presided over Mr. Wilson's co-defendant's preliminary examination and his presentation of the Burrell case. Now, although Mr. Martell never explicitly claimed that Judge Simpson had presided over the co-defendant's preliminary examination, stating instead that the examination had previously been held, both Judge Simpson and the prosecutor understood his argument to mean that Judge Simpson was the judge who had conducted the examination. This interpretation of Mr. Martell's argument is particularly understandable given the fact that the motion was premised entirely on Judge Simpson's prior involvement in the case, making the identity of the judge who presided over the co-defendant's examination directly relevant to the argument Mr. Martell was advancing. Now, as for the Burrell case, the portion of the decision that Mr. Martell emphasized in his argument addressed the concern that a magistrate who has already heard witness testimony might not be fully objective when later presiding over a preliminary examination. But the court limited its conclusion to circumstances where witnesses had actually been examined. In a section of the opinion that Mr. Martell did not address in his argument to Judge Simpson, the court determined that where the affidavit presented to the magistrate was in conclusory form, stated no underlying or operative facts, and no witnesses were examined, there was no prejudice to the accused in having that same magistrate preside at the preliminary examination. Here, Judge Simpson explained that he had reviewed the four corners of the affidavit, sworn in the affiant, and signed off on the search warrant, with no witness testimony taken, placing this case squarely within the circumstance that the Burrell case found unproblematic. Rule 3.3 of the Michigan Rules of Professional Conduct, the ethical rules governing professional misconduct, prohibits a lawyer from making false statements of fact or law to a tribunal, and from failing to correct a false statement of material fact previously made to the court. The comment to this rule expands on this concept, explaining that although a lawyer in an adversary proceeding is not required to present an impartial exposition of the law, the lawyer must not allow the tribunal to be misled by false statements of law or fact. Accordingly, a finding that Mr. Martell intentionally misled Judge Simpson with a false statement of law or fact could carry significant professional consequences under the ethical rules governing attorney conduct.
Then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly, Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
The one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, I do have a lot to say about the law, and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity, facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that I'm choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case.
The prosecutor argues that a judge who has reviewed and approved a search warrant may go on to preside over the case, citing the 2013 Michigan Court of Appeals case of People v. Cameron in support of her position. In the Cameron case, the same judge who presided over a bench trial where a judge decides a defendant's guilt rather than a jury had previously signed a search warrant authorizing a search of the defendant's home. The search warrant was accompanied by an affidavit containing potentially prejudicial information about the defendant's criminal history and alleged involvement in drug trafficking. On the first day of trial, defense counsel raised the concern that the information in that affidavit could have compromised the trial court's impartiality, and the trial court responded that it had no recollection of the specific information contained in the affidavit and found no merit to the issue. On appeal, the defendant argued that his trial counsel was ineffective for failing to move to recuse that judge. The Court of Appeals rejected the argument, holding that a judge is presumed impartial, that the defendant had failed to overcome that presumption, and that failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. Therefore, the prosecutor argued that if moving to recuse a judge who signed a search warrant and then presided over an entire bench trial was considered futile and meritless in the Cameron case, the motion to recuse Judge Simpson, who was only presiding over a preliminary examination, stood on even weaker ground.
It's from 1971. It's People v. Pitchford. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed, and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that Your Honor inappropriately approved a search warrant, and we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Just
Martel?
very briefly, and I would certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case. I can tell you probably weren't necessarily real excited about it, but that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to mislead this court, or in fact, I'm going to pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th.
Judge Simpson declined to rule on the motion from the bench, instead directing Mr. Martel to file a written motion. However, on January 2nd, 2025, Mr. Wilson entered a plea of no contest to 2 reduced charges, aggravated assault and attempted possession of a loaded firearm in a vehicle, with the remaining 6 counts being dismissed. He was sentenced on January 30th, 2025 to a minimum of 365 days in a county jail. This hearing illustrates the critical importance of candor in attorney communications with the court. The duty of candor is not simply a prohibition on making explicitly false statements. Attorneys occupy a unique role as officers of the court, and that role carries with it special obligations to avoid conduct that undermines the integrity of the proceedings. Although an attorney presenting a client's case has an obligation to do so with persuasive force, that duty of zealous advocacy exists in tension with the duty of candor to the tribunal. Those 2 obligations must be balanced, and the balance is struck through the recognition that while an attorney is not required to present an impartial exposition of the law, the attorney may not allow the court to be misled by false statements of fact or law. That principle extends to the presentation of legal authority. An attorney is not required to argue against his own client's position, but he is required to recognize the existence of pertinent legal authorities, and legal argument built on a knowingly incomplete or false representation of the law constitutes dishonesty toward the tribunal. The underlying concept is that legal argument is a discussion aimed at determining the legal premises properly applicable to a case, and that discussion cannot serve its purpose if the court is working from an incomplete or distorted picture of the law. Whatever the ultimate merits of the recusal argument presented in this hearing, the manner in which it was received by the court shaped the trajectory of the proceeding in ways that a more complete presentation of the authority